Okay, let's unpack this. A recent Supreme Court decision has just thrown a massive curveball into how federal courts can challenge the executive branch. It's a case that, well, on the surface, might seem incredibly technical.
Right, yeah, lots of legalese.
Exactly. It deals with something called universal injunctions. But what it really touches on is the fundamental question of who holds the power to make sure the government follows the law.
And crucially, what that means for you, the citizen.
Precisely. Today, we're taking a deep dive into the Supreme Court's ruling in Trump v. CASA, Inc. This decision was handed down just this week, June 27, 2025.
Super recent, yeah.
Our mission here is to strip away the legalese, get to the heart of what universal injunctions are, why the court's decision to limit them is so significant.
And what the differing views from the justices tell us, because there were very strong disagreements.
Oh, absolutely. We want you to get a thorough understanding of the arguments from all sides, have those aha moments, and come away truly well-informed about a decision that, honestly, could reshape how you interact with your government.
And for this deep dive, we've really dug into the source material. We've examined the Supreme Court's own words directly from the slip opinion.
Which is basically the first official version of the decision,
Yes,
right?
exactly. Hot off the press, so to speak. It includes the syllabus, that's the short summary at the beginning. Very helpful. The main majority opinion written by Justice Barrett.
Okay.
The concurring opinions from Justices Thomas, Alito, and Kavanaugh, who agreed with the result but had their own points to add.
Right. The concurrences often add important nuance.
They really do. And then, of course, the powerful dissenting opinions from Justices Sotomayor and Jackson.
So a really rich set of sources to work with.
Definitely. It lets us explore all the angles of this landmark ruling with some real precision.
Okay, so let's set the stage. This whole discussion, this legal earthquake, it kicked off with President Trump's Executive Order number 14160.
That's right. Issued earlier this year, February 28, 2025, it was titled, Protecting the Meaning and Value of American Citizenship.
And what was the core of this executive order? What did it actually try to do? And why did it immediately spark such a fundamental legal challenge?
Well, the order aimed to identify specific circumstances where a person born in the United States would not be considered subject to the jurisdiction thereof.
Okay, subject to the jurisdiction thereof, that sounds like language straight from the Constitution.
It is. It's from the 14th Amendment's Citizenship Clause. And the effect of the order saying certain people born here aren't subject to the jurisdiction would be that they wouldn't be recognized as American citizens at birth.
Wow. So this wasn't just a minor policy tweak.
Not at all. It was a direct challenge to what's been really a cornerstone of American law and understanding for over 150 years, birthright citizenship. The idea that if you're born on U.S. soil, you are a U.S. citizen.
Imagine the implications. A child born here, maybe to parents living and working here, suddenly denied citizenship.
That's exactly the scenario. It questioned that fundamental right granted to basically everyone born within the nation's borders since the 14th Amendment was adopted after the Civil War.
And what was the specific legal argument against the order? What did the challengers say was being violated?
The plaintiffs argued it directly violated two key legal texts. First, as we mentioned, the 14th Amendment's Citizenship Clause, Section 1. It states, quite clearly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
That seems pretty straightforward.
It does. And remember, that clause was specifically added to overturn the infamous Dred Scott decision and guarantee citizenship for formerly enslaved people.
The huge historical context there.
Absolutely. And second, they argued it violated Section 201 of the Nationality Act of 1940, which is the federal law that essentially codifies birthright citizenship.
So both constitutional and statutory grounds.
Right. The plaintiffs saw the executive order as trying to upend the principle of jus soli, the right of the soil, which has been fundamental, affirmed by precedent, like the Wong Kim Ark case in 1898.
That's the case involving the child of Chinese immigrants, right?
Exactly. The court affirmed his birthright citizenship, even though his parents weren't citizens. So this AO wasn't just a policy shift. It looked like an attempt to redefine something core to American identity, something legally settled for generations.
Okay, so given how fundamental this seemed, who actually brought the lawsuits against the president's order? Was it just a few individuals?
No, it was a really diverse and, frankly, powerful group. You had individuals, including pregnant women, who had a very direct, immediate fear their children would be denied citizenship upon birth.
Understandable.
Then you had major immigrants' rights organizations representing thousands of members across the country, collective interests.
Makes sense.
And maybe most significantly, you had 22 states, plus the District of Columbia and the city of San Francisco joining as plaintiffs.
Wow, 22 states. That's not insignificant.
Not at all. It signaled just how widespread the concern was. This wasn't just advocacy groups. It involved sovereign states worried about the impact on their residents, their budgets, their administrative systems. It highlighted the potential for massive nationwide disruption.
Okay, so these challenges go to the district courts. How did those courts respond? This is where universal injunctions enter the picture,
Yeah.
right? The core issue the Supreme Court just ruled on.
Precisely. And what the district courts did was quite striking. In all three separate lawsuits filed in Maryland, Massachusetts, and Washington, the judges entered universal injunctions.
And universal injunction means what exactly in practice?
It means they didn't just block the executive order for the specific people or states suing in that particular case. No, they issued an injunction barring executive officials from applying the executive order to anyone nationwide.
So one judge, in Maryland for instance, could stop this federal policy across the entire country.
Essentially, yes. The order was stopped in its tracks, protecting potentially millions of people, whether they were part of the lawsuit or not. And that broad reach of judicial power became the absolute heart of the matter when it reached the Supreme Court.
Okay, so unsurprisingly, the government wasn't thrilled with these nationwide blocks.
Not at all, especially since, as you mentioned, the underlying question is the executive order itself actually constitutional. Hadn't been decided yet.
Right. So what did the government do immediately?
They went straight to the Supreme Court with emergency applications seeking partial stays.
Partial stays, meaning they weren't trying to lift the injunctions entirely.
No, their goal was specific: limit the injunctions so they only protected the actual plaintiffs who brought the suit, not the whole country.
Okay, this is a critical point. Their argument wasn't our executive order is legal. It was.
It was purely about the remedy. They explicitly told the Supreme Court, we're not asking you right now if the EAO is constitutional. We'll fight that battle later in the lower courts. Their argument here was solely, do federal courts even have the power, the equitable authority, to issue these sweeping, nationwide, universal injunctions?
So they were challenging the tool the courts used, not the substance of the order itself at this stage.
Exactly. It was all about the scope of judicial power. And that's what makes this decision potentially so far-reaching, beyond just this specific case about birthright citizenship.
All right, let's dive into the Supreme Court's majority opinion then, written by Justice Barrett. They took a very clear stance on these universal injunctions. What was the core holding?
The core holding was quite direct. Justice Barrett wrote, federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them.
Okay, so courts stick to their lane, basically.
Right. And she continued, when a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power, too. The crux is their interpretation of the Judiciary Act of 1789.
The law that set up the federal court system.
Yes, and which grants federal courts jurisdiction over all suits in equity. The majority argues that this only includes remedies that were traditionally accorded by courts of equity back when the nation was founded.
Ah, the historical argument.
Precisely. And they concluded that these broad universal injunctions simply do not fit that historical mold. They weren't a traditional tool.
So it's a very history-focused interpretation of judicial power. If they didn't do it back then, courts can't do it now unless Congress explicitly says so.
That's the essence of the majority's reasoning. It's rooted in a specific view of equity as being defined by its historical practice at the founding.
And what was the immediate practical outcome of this ruling for the birthright citizenship case?
The government's applications for partial stays were granted, meaning the injunctions are now limited. They only applied to the extent they are necessary to provide complete relief to each plaintiff withstanding to sue.
So the executive order is no longer blocked nationwide.
Correct. For anyone who wasn't a named plaintiff in those three specific lawsuits, or isn't part of a certified class action later, the executive order could theoretically be enforced against them now.
Even though its constitutionality is still very much in question.
Exactly. It leaves many people in limbo while the main legal battle continues in the lower courts, and it shifts the burden significantly.
Okay, to support this historical view, the majority really dug into the past. What did they find looking back at English and early American equity courts?
They did deep dive. They looked at England's High Court of Chancery around the time the U.S. was founded. They found that, yes, equity aimed to provide justice where law was rigid, but the general rule was clear. All persons materially interested in the suit were to be made parties to it.
So everyone affected needed to be in the lawsuit.
Generally, yes. Injunctions were usually specific, restraining actions against particular plaintiffs. They didn't find anything, as they put it, remotely like a national injunction back then.
This historical evidence, or lack thereof, is central for them.
Absolutely central. If this powerful tool wasn't used or even contemplated when the Judiciary Act granted equity powers, the majority argues it can't be part of those powers now without explicit congressional okay.
Did they find the same pattern in early American courts?
They argued yes, that early U.S. courts followed a similar party-specific path. They pointed to cases like Scott v. Donald back in 1897.
What happened in that case?
A plaintiff wanted an injunction against a law that affected him and others, but the Supreme Court only allowed relief that benefited the named plaintiff himself, not the others. The majority sees this, and other early cases where courts refused relief to non-parties, as proof of a consistent tradition limiting remedies to those directly before the court.
This leads to what they called the conspicuous absence of universal injunctions for a long time. When did these things actually start showing up in federal courts?
This is where the timeline gets interesting. The majority says universal injunctions really were not a feature of federal court litigation until sometime in the 20th century.
Not until the 1900s.
According to their research, the very first one they identify came in 1963, a case called Wirtz v. Baldor Electric Syria from the D.C. Circuit.
Okay, 1963, that's relatively recent in legal history.
Right. And what they find particularly striking is the acceleration after the turn of the 21st century. One study they cited found about 127 universal injunctions between 1963 and 2023. But get this, over 3/4 of them, 96, were issued just during the Bush, Obama, Trump, and Biden administrations.
Wow, a huge spike in the last 25 years.
A massive spike. And for the majority, this absence from 18th and 19th century equity practice settles the question of judicial authority.
So the fact that they weren't used for centuries is definitive proof for them that they aren't legitimate now.
That's their conclusion. They argue equity's flexibility has limits, confined within the broad boundaries of traditional equitable relief. These modern universal injunctions, in their view, cross that boundary.
Now, the plaintiffs who challenged the executive order, they had their own historical arguments, right? They brought up something called a Bill of Peace.
They did. They tried to argue that universal injunctions are kind of like the modern version of this old equitable tool, the Bill of Peace, which did allow for group litigation.
How did the majority respond to that comparison?
They didn't buy it. They argued that while bills of peace allowed group litigation, they had specific requirements, things like a common interest, adequate representation, very similar to modern class action rules under Federal Rule of Civil Procedure 23.
Okay, so they saw bills of peace as more structured.
Yes, and they argued that universal injunctions, as used recently, lack those procedural safeguards. They essentially circumvent Rule 23's procedural protections and allow courts to create de facto class actions at will.
So it's seen as a shortcut around the established process for class actions.
That's the majority's view. They even asked rhetorically, why bother with a Rule 23 class action when the quick fix of a universal injunction is on the table? They see it as undermining the carefully crafted rules for handling large-scale litigation fairly.
That brings us to another key concept, complete relief.
Yeah.
The majority drew a sharp line, saying complete relief for a plaintiff isn't the same as universal relief for everyone. Can you break that down?
Absolutely crucial distinction for them. Complete relief, in the majority's view, means complete relief between the parties in the lawsuit. It's about fixing the specific harm suffered by the plaintiff who sued.
Not about fixing the problem for everyone who might be affected.
Exactly. They acknowledge that a party-specific injunction might incidentally help others. Maybe the government changes its policy universally in response, but that's a side effect, not the required scope of the relief itself.
So for the individuals and groups suing over the birthright citizenship order,
the majority said stopping the government from enforcing the order against their specific child or their members gives them complete relief. Making the injunction universal wouldn't make their relief any more complete. It would just give relief to people not before the court.
a very narrow view of what complete means in this context.
It is. It's focused solely on redressing the injury of the party who brought the case.
But the states involved had a different argument, right? They claimed they needed universal relief because of practical administrative problems.
They did. The 22 states made a compelling case that their specific harms, things like financial costs, administrative chaos in running benefits programs that depend on citizenship status, simply could not be fixed without a nationwide ban on the executive order.
What was their reasoning?
They pointed to the reality of people moving between states. Imagine a child born in state A, where the EO is blocked, then moves to state B, where it isn't. How does state B administer benefits? They argued a patchwork injunction would be totally unworkable, forcing them into complex tracking and verification, creating huge burdens and risks of error.
That sounds like a very practical nightmare for state agencies.
It does. For the states, a limited injunction wouldn't feel complete at all because it wouldn't solve their core administrative and financial problems.
So how did the Supreme Court majority deal with these practical arguments from the states? Did they engage with them?
Interestingly, they mostly sidestepped them for now. The majority declined to take up these arguments in the first instance.
Meaning they kicked the can down the road.
Essentially, yes. They sent it back to the lower courts to figure out whether a narrower injunction is appropriate for the state plaintiffs and to consider those complex administrative arguments on remand.
So the scope of relief for the states is actually still up in the air.
To some extent, yes. The lower courts now have to grapple with whether any form of injunction for the states, even if not fully universal, is needed to provide them complete relief, keeping the Supreme Court's new limitations in mind. It shows maybe some recognition of the state's unique position, but still a clear preference for narrow remedies overall.
Beyond history and definitions, the plaintiffs also made policy arguments. They said universal injunctions are often the only practical way to quickly protect large groups, ensure fairness, stop piecemeal litigation. How did the majority respond to those points?
They acknowledged those arguments, but ultimately deemed them beside the point.
Beside the point, why?
Because, for the majority, the fundamental question was about the court's historical authority. If the power wasn't granted historically, then arguments about whether it's useful or efficient today don't create that power.
So history trumps policy, in their view.
That seems to be the hierarchy here. They did concede, maybe slightly, that there may be good reasons not to issue universal injunctions in the typical case, but they immediately pivoted back, calling the universal injunction a new potent remedy with new potent risks. It highlights that core disagreement. Should judicial tools adapt to modern government or stay fixed by historical practice? The majority clearly chose the latter.
And one final point from the majority. They argued these injunctions cause irreparable harm to the executive branch itself. How did they justify that claim?
Their reasoning is rooted in the separation of powers. They argued that when a lower federal court issues a universal injunction, it improperly intrudes on a coordinate branch, the executive. It stops the government from enforcing its policies against non-parties, people who haven't sued.
Even if the policy might eventually be found illegal.
Yes. The majority views the act of stopping nationwide enforcement before a final decision on the merits as, in itself, a form of irreparable harm to the president's ability to execute laws and implement policy. It prevents the executive from carrying out its functions, interfering with its constitutional role.
So the harm isn't necessarily about the substance of the policy being stopped, but the very act of a court intervening so broadly at an early stage.
That's the core of their irreparable harm argument. It emphasizes allowing the executive branch room to operate without what they see as premature, overly broad judicial interference.
Okay, so that's the majority view. But the concurrences, Justices Thomas, Alito, and Kavanaugh added their own layers. Let's start with Justice Thomas. He focused on this complete relief idea being a ceiling.
Yes, Justice Thomas wrote separately to really hammer home that complete relief is the absolute maximum a court can provide. It's a ceiling, not a floor. And crucially, it must always be narrowly tailored to fix the plaintiff's specific injury.
He seemed worried courts might try to stretch the definition.
Exactly. He warned against distorting the principle to achieve the same broad results as universal injunctions through other means. He even brought up the old frothing MV Mellon case from 1923, where the court rejected a nationwide injunction sought by a taxpayer, saying sometimes courts just have to make do with less than complete relief if the broader fix isn't traditionally available.
So his focus is really on reining in judicial remedies, keeping them minimal.
Very much so. A strong emphasis on judicial restraint and sticking strictly to redressing the individual plaintiff's proven harm.
Okay, then Justice Alito. His concurrence focused on something different. Third-party standing limitations. What was his concern there?
Justice Alito flagged a potential future issue related to who can sue on behalf of whom. Generally, you can only sue to protect your own rights, not someone else's. It's the basic idea of standing.
Right.
Alito worried that states might try to get around this ruling by suing to protect the rights of all their residents. If a state sues and gets an injunction covering everyone in the state, isn't that achieving broad relief, maybe even broader than an individual could get?
So states could become a sort of proxy for universal relief, just state by state.
That's the potential Alito sees. He specifically said if states can do this, they'll have every incentive to bring these third-party suits to get broader relief than individuals can. He suggests this could undermine the whole point of today's decision limiting universal injunctions.
So he's calling for courts to be really strict about letting states sue on behalf of their residents in this way.
Yes, rigorous and even-handed enforcement of those third-party standing rules to prevent this potential workaround. It points to where future legal battles might be fought.
Interesting. And finally, Justice Kavanaugh's concurrence. He often tries to map out practical pathways. Did he suggest other ways litigants can still get broad relief?
He did. Kavanaugh made it clear that while universal injunctions from single judges in single cases are now limited, the courthouse doors aren't closed for broad relief entirely.
What avenues did he point to?
He explicitly mentioned Federal Rule of Civil Procedure 23b2 class actions. Those are specifically designed for cases seeking injunctive relief for a whole group, whole class people affected similarly by a policy.
So class actions are still a viable tool for nationwide challenges.
According to Kavanaugh, yes. He also mentioned challenges under the Administrative Procedure Act, APA, where courts can set aside unlawful agency rules, which often has a nationwide effect.
Okay, so APA challenges and class actions remain key strategies.
Right. And he also noted pragmatically that even a party-specific injunction might, in practice, benefit others if the government changes its behavior across the board in response. His concurrence reads a bit like a guide. This one tool is limited, but look, these other tools still exist.
Kavanaugh also talked about the Supreme Court's own role. What did he say about the court potentially needing to step in more often or earlier?
This was a fascinating part of his concurrence. He suggested that the Supreme Court itself often ends up being the ultimate decider on the legality of major new federal policies, at least on an interim basis.
Meaning the court takes on the role that maybe lower courts with universal injunctions were playing.
In a way, he acknowledged the concern that limiting universal injunctions might push controversial issues to the Supreme Court faster, but he argued that for clarity, stability, and uniformity nationwide, it's often important for the Supreme Court to step in and provide a single national answer, even if it's on an emergency or expedited basis.
So, less power for individual district judges, but potentially a more centralized, rapid role for the Supreme Court in these big policy fights.
That's the implication. Kavanaugh seems to see the court as needing to provide that national resolution when lower courts are issuing conflicting or limited rulings. It's a subtle but important potential shift in judicial power dynamics.
All right, let's pivot to the dissents. Justice Sotomayor, joined by Justice Jackson, wrote a very powerful dissent. She started by arguing the executive order itself was so clearly illegal that the government shouldn't get any relief.
She absolutely pulled no punches. Her starting point was the patent unlawfulness of the citizenship order. She argued that alone was reason enough to deny the government's applications for a stay.
Why did she see it as so unquestionably unconstitutional?
She laid out a detailed case based on, well, centuries of understanding. The plain text of the 14th Amendment, its history overturning Dred Scott, the landmark Wong Kim Ark ruling confirming birthright citizenship, the Nationality Act of 1940, even the executive branch's own a long history of recognizing birthright citizenship going back decades.
So for her, the violation was just black and white.
Absolutely. She saw the order as flying in the face of firmly established constitutional text, history, precedent, and statute. In her view, the court shouldn't even be debating the remedy when the underlying action is so fundamentally wrong.
And if the order is unconstitutional, How did she respond to the majority's claim that the government suffers irreparable harm from being enjoined?
She found that argument completely illogical, self-refuting, she called it. Her point was simple. If the executive order is unconstitutional, the government has no right to enforce it against anyone.
So stopping illegal action can't be considered harm.
Precisely. She asked, how can maintaining a centuries-long status quo of birthright citizenship for a few months longer possibly injure the government irreparably? It defied logic for her.
Did she use any analogies?
Yes, powerful ones. She asked if the court would say the government was irreparably harmed and needed emergency relief if an injunction stopped an executive order denying unemployment benefits to women or voting rights to Black citizens. Her point was clear. Stopping unconstitutional action prevents harm. It doesn't cause it. The injunctions, she argued, were upholding the Constitution and federal law, not improperly impeding the government.
Justice Sotomayor also tackled the majority's historical argument head-on, offering a different take on equity's history.
She did. She argued the majority's historical test was too rigid, too frozen in amber. She countered that while English injunctions were usually party-specific, they weren't always so.
What historical examples did she use?
She pointed to bills of peace and taxpayer suits as historical tools where equity courts could resolve issues affecting entire communities, even with just one plaintiff. She also cited key American Supreme Court cases.
Like which ones?
Cases like Lewis Publishing from 1913 involving postal rules, Pierce v. Society of Sisters in 1925 blocking that Oregon mandatory public school law, and the famous West Virginia v. Barnett flag salute case from 1943. In all those, she argued, the court affirmed or granted broad relief protecting non-parties.
So her view is that equity has always been more flexible and adaptable than the majority allows.
Exactly. She sees equity's core purpose as providing effective justice, which sometimes requires remedies that go beyond just the named plaintiffs, especially when facing widespread government action.
If universal injunctions were rare before the late 20th century, how did Justice Sotomayor explain that historical gap differently from the majority?
This was a key part of her counterargument. She argued the scarcity wasn't because equity lacked the power, but because of other procedural and constitutional barriers that prevented such lawsuits against the federal government for much of American history.
Barriers like what?
Things like sovereign immunity. The government couldn't easily be sued at all until waivers like the Administrative Procedure Act in 1976. And strict rules about jurisdiction and venue often meant you could only sue federal officials in Washington, D.C., making nationwide relief impractical.
So the ability to bring these broad challenges changed over time.
Yes. So for Sotomayor, the recent rise of universal injunctions isn't some radical departure. It's equity's essential adaptation to modern governance. As the old barriers fell and the federal government's reach grew, equity naturally adapted to provide effective remedies. It's a dynamic view of judicial power, not a static one.
She also argued that even under the majority's own complete relief standard, the universal injunctions were justified, especially for the states and the associations.
She did. She basically said, okay, even if we accept your narrow complete relief test, these injunctions still meet it. For the states, she agreed with the lower courts. The cross-border movement of people and the administrative nightmare of a patchwork system meant only a universal injunction could provide complete relief from their specific harms.
And she criticized the majority for punting that issue back to the lower courts.
Yes, especially since the government hadn't even proposed specific narrower remedies for the states and the lower courts. She felt the majority wasn't fully grappling with the practicalities the states faced.
What about for the individuals and the immigrant rights groups? Why was universal relief complete relief for them in her view?
Again, practicality. Given thousands of members across all 50 states, an injunction limited only to named parties would be unworkable. How do you track who's a member? How do parents prove membership status at a hospital? It would create chaos, burdens, and huge risks of mistakes and noncompliance.
Especially, she noted, given the nature of the executive order itself.
Right. She pointed out that the EO showed an utter disregard for settled precedent, suggesting the government couldn't be trusted to apply even a narrow injunction properly and might try to enforce the EO against non-parties anyway. So a broader injunction was necessary to provide actual, practical, complete relief from the threat.
Given the court's ruling limiting universal injunctions, Justice Sotomayor pointed towards class actions as an alternative, but with some serious warnings.
Yes. She acknowledged Rule 23b2, class actions are a potential path for broad injunctive relief. But she immediately highlighted the major hurdles.
Like what?
Proving all the prerequisites, numerosity, commonality, typicality, adequacy, she said, is difficult and time-consuming and has been getting harder. Plus, defendants can immediately appeal a class certification decision before the case even gets to the merits.
Which will bog things down.
Exactly. Creates a drawn-out procedural bog with significant expense and delay. She even noted the government in this very case wouldn't commit to not fighting class certification if plaintiffs tried that route.
So it's an option, but not an easy one.
Not at all. Still, she advised the parents affected by the order would be well advised to file promptly class action suits and seek temporary relief for the potential class. It's a difficult path, but maybe the main one left for broad protection.
Now, Justice Jackson joined Sotomayor's dissent, but also wrote separately, arguing the majority's technical focus was a smokescreen. What did she see as the real fundamental question?
Justice Jackson cut right through the historical debate. She argued the mind-numbingly technical query about old equity practices obscured the real issue, which she framed simply and powerfully. May a federal court in the United States of America order the executive to follow the law?
Framing it as fundamental to the rule of law itself.
Absolutely. She called the situation an existential threat to the rule of law. Our government is meant to be governed by those impersonal forces which we call law. When the executive asks not to be universally stopped from potentially unconstitutional actions, she argued, it's basically asking for permission to engage in unlawful behavior.
And the judiciary's role
is to deny that permission. If this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny it. For her, limiting the court's power to enjoin illegal executive action creates a dangerous zone of lawlessness.
This zone of lawlessness idea is stark. How did she describe the two-track legal system she fears this ruling creates?
She painted a very grim picture. Track 1, where law reigns, that's for the named plaintiffs to get an injunction. Their rights are protected. Track 2, the majority's ruling endorses the creation of a second zone for everyone else who hasn't sued.
And in that second zone,
all bets are off. People are left to the prerogatives of the executive as to whether their constitutional rights will be respected. And crucially, she warned this prerogative zone won't affect people randomly. It will hit the poor, the politically unpopular, the marginalized hardest, those without the resources or ability to go to court themselves.
a very strong warning about unequal justice.
Incredibly strong. She called it eerily echoing history's horrors and anathema to the rule of law. It's a powerful critique, arguing that rights aren't truly universal if the remedy depends on your ability to individually sue the government.
Justice Jackson also emphasized that the Constitution limits all branches, not just the courts.
Yes, she pointed out that while the majority stressed limits on judicial power, they seem to forget or ignores that the Constitution and Congress also limit the power of the executive. And because the executive wields actual force, its power is uniquely harmful when unconstrained by law.
So the judiciary's check is essential.
Absolutely essential in her view. She questioned how Congress, through the Judiciary Act, could possibly have intended to strip courts of the power to order the executive to stop acting unlawfully. Allowing the executive to act potentially illegally towards large groups of people simply because they haven't sued yet undermines the entire concept of a government of laws.
Okay, so after working through all those arguments, majority concurrences, dissents, let's bring it back. What does this ruling mean right now for the specific case? Trump v. CASA, Inc.
For this case, the immediate impact is clear. The nationwide injunctions blocking the executive order on birthright citizenship are lifted. Enforcement is now limited only to the specific plaintiffs who sued.
The big question is, the executive order itself constitutional? Is still unanswered by the Supreme Court.
Still completely unanswered by them. That core legal battle goes back to the lower courts to be decided on the merits, assuming the cases proceed. So the policy is partially back in effect, but its ultimate legality is still in doubt.
And zooming out to the broader implications, what does this mean for executive power going forward?
It arguably gives the executive branch more breathing room to implement policies, even legally questionable ones, across the board. The main check, a swift nationwide invention from a single judge, is now much harder to obtain. Policies might affect millions before courts can fully intervene through narrower injunctions or lengthy class actions.
And for judicial power.
It definitely curtails the power of individual federal district judges to issue these broad, sweeping remedies. It pushes the system towards more plaintiff-specific relief or towards those more complex, slower processes like class actions. It might also centralize power more in the Supreme Court itself, as Kavanaugh suggested, to provide ultimate national clarity.
So for you, the listener, the citizen,
Yeah.
what's the takeaway? What burden shifts now?
The practical burden of challenging potentially unlawful executive action shifts more heavily onto individuals and groups. You can't necessarily rely on one lawsuit somewhere else to protect your rights nationwide, at least not immediately. You might need to be part of a specific lawsuit or a certified class action.
Which raises huge questions about access to justice, right?
Absolutely. Does everyone have the resources, the knowledge, the ability to sue the federal government? If not, does this create a system where rights are protected for those who can afford to litigate, but not necessarily for everyone else? That's the fear Justice Jackson voiced so strongly.
And how might we see litigation strategies change now?
We'll likely see litigants lean more heavily on Rule 23 class actions, despite the hurdles Justice Sotomayor described. We might also see more challenges brought under the Administrative Procedure Act, seeking to have rules set aside. And we could see a more fragmented legal landscape, patchwork injunctions where a policy applies in some places but not others, leading to confusion and inconsistency, at least until the Supreme Court weighs in definitively on the merits. Ultimately, this deep dive just reveals this profound tension that's always there in our system. It's the balance between the judiciary needing the power to check the executive branch versus the historical and procedural limits on how courts can wield that power.
A real clash of philosophies.
Definitely. The majority prioritized historical practice and procedural order. The dissents emphasize the practical need for robust judicial checks to prevent executive overreach and ensure rights are protected universally, arguing equity must adapt. It's a fundamental disagreement about the role of courts in modern society.
So, to recap, we've dug into Trump v. CASA, Inc., unpacking the Supreme Court's big decision limiting universal injunctions. We explored the deep historical dives, the arguments over complete relief, and those really stark warnings from Justices Sotomayor and Jackson about zones of lawlessness. It's complex, no doubt, but so crucial for understanding power in our democracy.
And how that power balance directly impacts your rights.
Exactly. So as you reflect on all this, here's a final thought for you to mull over. With this traditional tool of the universal injunction now significantly curtailed, and the burden shifting more towards individuals or these complex class actions, what stands out to you about how this decision might really shape that balance of power between the president and the courts? And maybe more importantly, how might it affect ordinary people trying to protect their constitutional rights in the years ahead?
Lots to think about there.
Definitely. We encourage you to keep asking questions, keep digging deeper, and keep seeking to be well-informed.